disciplinary action leading up to termination. My name is Julie Dorr, and I will be your moderator for today's event. Our presentation will last approximately 40 minutes with the remaining time available for Q&A. If during the presentation you have any questions at all, feel free to type them in the designated section to the right. There's actually a box that's called questions. You just need to expand that and type your question right in there. And we'll answer all of them, or not all of them, many of them at the end of the webinar. We do have a big crowd on today, so go ahead and even put your questions in there. And if we can't get to them, I will send them on to our speakers today so they can follow up with you directly. Earlier this morning, we did email you a link to a copy of our presentation. If you haven't received it, feel free to email me right now at julie@thedoorgroup.com. And again, my email is on the screen right now, and I'll send that document to you right away. Before we get started, though, just note that this webinar and all of the accompanying materials are protected by copyright and that the entire conference is being recorded. This presentation provides general information only and does not constitute legal advice. If you need legal advice, please consult with your own legal counsel to address your specific situation. So let's get started by welcoming today's expert panel. First, we have Linda Duffy, President of Ethos Human Capital Solution. Linda works with business owners and executives to provide strategic human resources direction, develop leadership talent, and increase organizational effectiveness. And then, of course, we have attorney Marla Merhab Robinson. Marla is with the law firm Merhab Robinson, Jackson, and Clarkson, where she's a partner and head of the firm's transactional department. She primarily practices in the areas of corporate, mergers and acquisition, real estate, finance, and employment law. So again, as I said, we have a big crowd. This is always a popular webinar for us. So I'm going to turn over to Linda so we can get started right now.
Julie, thanks so much, and thanks everyone for joining us today. Before we get started, I just wanted to make one announcement for everybody, and that is that so often I get asked this question. I'll go into a company and I'll do anti-harassment training in person for managers or for all employees, but everyone probably knows that if you have more than 50 employees in California, there's a specific requirement under an assembly bill that was passed a number of years ago to provide 2 hours of interactive anti-harassment training for managers. And what happens is I'll go in and I'll do the training for everybody except someone calls in sick, someone's on vacation that week, whatever. So the good news is we're going to do a little makeup webinar-based version of this for a few of my clients, and we're going to open up to the public as well. So if you have any managers that you want to be trained on and compliant with AB 1825 specifically, then this is a registration right here that you can go ahead and get them registered. The cost is only $39, so it's very cost effective, and it will be 2 hours and it will be interactive. After the webinar is over, I will issue some form of certificate to the manager so they can give it to HR or whomever to be placed in their file as a record of the training. And that registration is also on the final slide as well, so in case you're not able to write it down right now, and it should be in your handout as well. Okay, so let's get started by just going over the agenda real quickly. As Julie mentioned, this is one of our most popular webinars we've done in the past, and we have close to 150 people actually register for it today. So we're going to go over the basics of disciplinary action. Going to talk about at-will and some of those exceptions to at-will. Marla's going to spend a lot of time talking about terminations and sort of, you know, as she says, there's risky, riskier, and riskiest, and how to sort of lower the risk on that scale. Some things you can do from a pre-termination checklist standpoint, and then just sort of other considerations. We're going to go through really fast because I know there's going to be a lot of questions out there, and as Julie already mentioned, go ahead and just type those in. The system has a place for questions or for chat. Type them in there, and then Julie will make sure to ask as many as possible. The other thing to note for today is we're not talking about collective bargaining agreements, so if you work for a union company, all bets are off because you may actually have that spelled out in your CBA. So this is for everybody else. So the first thing I want to talk about is just alternatives to discipline. So I'm going to walk you through sort of different disciplinary processes you can use, but you have to keep in mind also you've invested a lot of time and money in recruiting and training people. So it doesn't always make sense to put people on the path toward termination right away. So hopefully you can take a look and step back and say, well, is this really a situation that warrants discipline? Or is this a situation that really requires some additional training? Or maybe it's coaching. Maybe the person is not right for this position. Maybe we just made a mistake in hiring them, or they weren't clear about their background and we didn't do a great job asking them questions. But you know what? They're good at certain things, and if we just move them to another position or something like that, it would be beneficial to them in the company, and we could avoid walking down that termination path. Now, I'm also to tell you, never transfer a problem. So if the person has wrongdoing, if the person has bad attendance, but when they're here, they're great, all of those type of problems, then you want to try to make sure that you're, course correcting with them as early as possible and not just transferring a problem. But if there's a way to avoid, the disciplinary action on the path to termination, at least ask yourself those questions. When we're talking about discipline action, we want to make sure up front that we are very clear about expectations with employees. So I know for me personally, it's really frustrating if somebody says that I did something or didn't do something or somehow didn't meet their expectations when I feel like I never knew what they were to begin with, right? And I think generally speaking, a lot of companies don't do a great job about sort of outlining for employees when they join the company what's expected of them. And there's a lot of ways that you can do that. Hopefully you have at-will language in your handbook. You should also include in your offer letters, maybe even on your application form. So that sets an expectation, at least, about the relationship between the employee and the company. In all the handbooks we write for clients, we have a list of standards of conduct that spell out really clearly what's acceptable and what's unacceptable conduct. We also have an attendance policy. It varies by company, but it's something that we put in writing so people have a clear understanding of what's expected and how they're going to be measured on attendance. Hopefully you have some sort of onboarding or orientation process where you can review performance standards, you can talk about those expectations, and also outline for them, look, if something does not meet our expectations, here's sort of the process we take, even if it's not a step-by-step sort of progressive disciplinary approach. And so there is some benefit to progressive discipline because, it's logical, let's say, for an employee to say, okay, we're going to go from a verbal warning to a written warning, maybe a suspension before discharge. I will also tell you I'm not a huge fan of relying on that because I don't like, when I talk to my clients, I don't want to put them in a box or put so many, rules around how they can interact with their employees, because there may be times where it's, it doesn't make sense to start, with a verbal warning. It needs to be right away a written warning, or maybe you just need to fire somebody on a first offense. So there's different things there, but some companies do like to use the progressive discipline, and this is sort of what I mean by that, starting with a verbal warning when there's a problem and then escalating it from there. But again, all steps should have the goal of correcting that performance or behavior issue and also letting people know the consequences if they fail to correct that. So let's talk about those different steps, and then you can decide for yourself whether or not you want to use these at your company. So the first step often is just a verbal warning, and I think a lot of people tend to overthink this. So it doesn't have to be anything super formal. It's just a matter of, I could say, Julie, I'm going to pick on you today. I could just pull Julie aside and say, hey, Julie, you know what? I've been noticing you've been coming in late a lot. What's going on? We need to try to get back on track and get here every day at whatever time, right? It could be as simple as that. That could be a verbal warning. So it doesn't have to be, super formal or anything like that. A lot of times it's just one-on-one between the manager and the employee. Think about, what it is that you want to communicate to the employee in advance. By all means, meet with the employee in private. If you're going to be behind closed doors, I always recommend having a third party present so it doesn't open up another can of worms from a harassment standpoint or something like that, or someone can't claim something happened. But state clearly that you're issuing a verbal warning. Tell them what the concerns are, what they're doing that's not meeting your expectation. Remind them of what your expectations are, and then also let them know that, hey, if we don't see immediate sustained improvement, here's what's going to happen. Right? And so just document that conversation. You can document on a calendar, send yourself an email, send an email to HR, whatever your company policy is, but do something so you have some record of the date when you actually had that verbal discussion with somebody, and if there were if they said anything back to you, try to document what their language was. Julie agreed that she's been late too often and she'll, be better about being on time or something like that. Okay, the next step in the process for a lot of companies is the written warning. This is where it gets a little bit more serious, and I would definitely suggest having another manager, HR, or witness, somebody there as part of the conversation. So if you're a manager, you're going to pull somebody aside, pull somebody in as well. So again, there's no confusion about what actually took place. Now, there's two different schools of thought on this. Some people have like a written warning form that gets filled out. Really common to see that with sort of, we'll say, blue collar, manufacturing companies, that type of thing, where it gets, filled out ahead of time. You're pretty much handing it to the employee. If you're lucky, people are saying a few words about it and having a discussion, and then asking the employee to sign it. For professional service firms, I don't find that that works as effectively because it can seem a little, I don't know, a little paternalistic or demeaning to employees. And so a lot of times I say, just write a memo. Sit down with the employee and say, essentially, hey, I got to talk to you about this performance issue. You're not meeting my expectations. Here's what's going on. If you've given them a verbal warning in the past, remind them about the verbal warning and any other type of notification they had. Hey, this policy is outlined in the handbook, or we issued a separate policy about this, or whatever the case is. Go through everything and then make sure that they're clear on what the expectations are going forward. Always have the employee sign a copy for the personnel file. Sometimes the employee, I just had this happen a couple weeks ago with a client. We did an investigation. It revealed some conduct that we felt warranted a written warning, put in front of, two employees were involved, put it in front of the employees, they refused to sign. If that's the case, then that's why, again, you have a second witness there, so you can say essentially, hey, employee refused to sign, you just make a note of that, and it still goes in their file. One of the things in the written warning I always suggest that people include is this phrase that I have up on the screen right here, which is failure to demonstrate immediate and sustained improvement may result in further disciplinary action up to including termination of your employment, or up to including discharge, or whatever phrase that you like. One of the things that happens, sometimes I see companies or managers say, in the next 60 days or something like that, you have to do something, or, we need to see something in a certain period of time. I tend not to put a certain period of time in there and instead say immediate and then also sustained improvement, because you don't want to box yourself in that you've given an employee 30 days to correct their behavior, but they don't. Do you really want to keep them around 30 days? Or what if they do something there's a violation of another policy the next week. It's so don't commit yourself to any specific length of time. Make sure they understand they have to do it right away, and they have to continue doing it in order for that to meet your expectations. For companies using progressive discipline, this third step in the process is often a suspension. And as a company, you need to think through a few things and decide whether or not this is a step that you want to take. Some companies will suspend without pay. Some companies will suspend with pay. It just depends, and I've worked with both of those type of companies before. So document it as you would a written warning. Think about the circumstances. Is this something that the person is, obviously done something so egregious that you certainly don't want to pay them to go home? Maybe you have a company policy that says, what, we just want employees to take a step back, go away for a day or two, think about whether they want to re-engage with us, and if not, that's fine. We're willing to pay for them that day off. Certainly don't give them a long weekend. And also the other concern to be aware of is if you're going to suspend them for any length of time, like 3 days or something like that, my concern is always if the employee all of a sudden has, some sort of disability come up in those 3 days, or somehow has, a workers' comp injury happen or something like that. So anytime you are making a decision to suspend or terminate but not taking action right away, those are some of the concerns you have to think about as you're making those decisions. From a disciplinary action checklist, here are some of the things that you want to make sure. First of all, that it's an appropriate proportional response. Is this a one-time serious infraction like theft or workplace violence or, falsification of documents or something like that? It may warrant termination right away. Is it an ongoing issue like attendance or just not meeting performance standards or something like that, then maybe you do go through more of a progressive disciplinary approach with them. You want to make sure that you're always consistent with your policies and practice. So what does your handbook say? It's one of the first questions I ask the client. What does your handbook say you're going to do? What does your handbook say about that expectation or that standard of conduct? And also take a look at what you've done in the past. You certainly always want to review it to make sure that you're consistent. You don't have to treat all employees the same all the time, but you need to look at similarly situated employees and circumstances and make sure that you're consistent in how you're addressing them. And that sort of rolls into the next one, which is, make sure it's uniform. So if I, handled this situation with attendance this way last time, then I should probably do it the same way this time and not all of a sudden fire somebody on their first absence. Always make sure you're being objective. What are the facts? Did you conduct a fair and sufficient, investigation? Did you take a look at things objectively and not attach your meaning to the facts, right? Because sometimes people make assumptions about what that means. Oh, that person took Tuesday off. Clearly she's interviewing for a new job, so we should just fire her. People make all sorts of sort of leaps in logic sometimes, so you want to make sure that you're just looking at the facts. She missed last Tuesday. Okay, how many of the days has she missed? Those type of things. Obviously, you want to make sure it's not a surprise to the employee. Excuse me. This comes up all the time where the employee all of a sudden says, what are you talking about? I just got a call right before this webinar about going out and doing an investigation for a client, and the employee is sort of surprised. She's like, well, what's going on with this? Nobody's ever told me I'm not meeting expectations, and then all of a sudden this happens, right? So you want to make sure, and especially at the time of termination, it's never a surprise for the employee. They have clearly understood your expectations. You've told them they're not meeting them. You've told them of the consequences. And then the last one, of course, that it's timely. You want to address issues as they happen, and let me tell you, ignoring them never fixes the problem. Okay, so it's fine to say, you know what, this is a situation, but because of business decisions, we're going to start a search for a replacement before we fire them, or something like that, and that's fine. Just document your decision making. If you're giving somebody feedback on their performance or expectations, don't wait for a few weeks or a month and then say, oh yeah, remember that happened a month ago, because the odds are they're not going to remember. So you want to try to do things in a timely manner. So there are a lot of things that are considered documentation, not just like a formal written warning or documentation of a suspension or anything like that. Certainly records of verbal written warnings are, but also, again, as I mentioned before, you have at-will language in hopefully your application forms, your offer letters, and your handbooks. You have standards of conduct in your handbooks that probably just list things, not all-inclusive, but list things that are inappropriate for you. You have other written policies. You have training records. Maybe you sat down, or maybe it's onboarding, but you have some sort of record of talking with the employee and letting them know your expectations. The rest of them you can see as well, performance appraisals, everything else. So you don't have to always think, oh, did I write that person up, per se. It could be, you know what, we made a note of that in their last performance appraisal, they're missing too much time. And so reference that in the next step of the process as the first notice or the first record you have of warning them. Make sure you're training your managers on how to properly deliver warnings. The investigation I just mentioned, that's going to be at the heart of the issue. I already know from just the little conversation I had with the CFO today. An employee feeling like she, people are not being forthright with her about what the real issue is. So you want to make sure that you're always, again, just really clear with employees, and you've trained your managers on how to have a difficult conversation, because a lot of people are not comfortable providing feedback when their expectations are not being met. Now, my personal favorite standard of conduct I just like to share with everybody, so if you have a list, make sure you include this in your handbook, and that is conduct which tends to destroy harmonious relationships with or among employees, vendors, clients, or the community. So how many of you have had that situation where the person's technically meeting performance standards but they just don't get along with people, or their behavior in the workplace, it's not necessarily a violation of a policy, it's just no one wants to work with them. You know, for whatever reason, they're just a pain. And so what we do is we include this in the handbooks when we write it, and you'd be amazed how many things you can sort of hang your hat on and put under this umbrella to say to people, look, yeah, you know, you're meeting your performance expectation, but how you're doing it, or your attitude, or anything like that, how you're getting along with other people, you just can't play nice with others, and it's destroying relationships. And based on that, we're writing you up, or we're going to fire you. Now, the last story I'm going to tell you before I turn this over to Marla to talk about termination is what I call the Sally lesson. I was really blessed very early in my career, 30 years ago or so. We were working in a manufacturing company, and Sally had been with the company about 10 years. She was African American, and she was over 40. So I tell you that because Marla is going to talk about how protected characteristics can make some terminations a little bit more difficult. Her performance was okay when she was there, but she had really bad attendance. And a new manager came into that department and came to me and said, you know, I think she needs to be written up, but I'm really afraid to do it because you know, when I've tried to give her some coaching, she doesn't really respond to that, and the prior managers had always just let her get away with it, right? So she said, I'm going to be the bad guy. Everyone's going to hate me because everyone loves Sally, and if I write her up or I fire her, they're all going to hate me. And the lesson I got from that was this. Not only when she wrote up and eventually fired Sally did that not happen, but exactly the opposite happened. Sally's coworkers came to the manager and said, finally, thank you so much for stepping up basically and being the manager that you're supposed to be. Everyone else let her get away with this forever, and finally, you know, they had a manager they could respect. So not only did she not, you know, have that negative action that she thought she would on all the rest of coworkers, but again, exactly the opposite happened. So a lot of times I remind managers that there are consequences to not taking action as well. Everybody's afraid of losing their star performers, and one surefire way to do that is to have a situation where you're not taking the appropriate action because people start to question your leadership skills. So with that, I am going to turn it over to Marla and let her talk about terminations.
Thank you, Linda. And I'm going to start with an apology to everybody. I'm just coming off of laryngitis, so I'm hoping that my voice will hold out. And fortunately, I won't be as long as Linda, so we should be okay. Linda was talking about difficult conversations that people don't want to have. Giving discipline is difficult, but if that's difficult, terminations are nearly impossible. I know, as Linda said, many clients who get frozen because they don't want to take that next step on terminations. All terminations come with risk in California. We have a highly litigious state, very employee-favored state, and so all terminations come with that risk that the employee is going to turn around and file some sort of claim. Our jobs, both all of you on the line as managers and HR directors and Linda as a consultant and myself as an attorney, is to do everything we can to lower that risk. And all of those processes and procedures that Linda just went through are excellent at doing just that. So if you got nothing else out of today but follow Linda's recommendations and advice on the first half of this, it would be well worth it because you'll save your company a lot of money. So let's just start with the basics. Most everyone here probably knows employment in California is at will. It's per Labor Code Section 2922. It's set forth on this slide as the actual language in the statute, saying an employment having no specified term may be terminated at the will of either party, meaning the employee can walk away at any time, and so can the employer, on notice. I'm going to ask everyone underline, if you're looking at paper, the word notice, because there's two notice requirements on termination we'll talk about. You need to give notice that they're terminated. You can't just expect them to know. To the other, employment for a specified term means an employment for a period greater than 1 month. So on the next slide, we have a sample policy of at-will language. This is usually the type of policy we'll see in a handbook. But as Linda suggested, it should be found in nearly every communication with employees, certainly not emails back and forth, but any communication having to do with their employment terms. So if there's a change in their employment terms, you amend an employment agreement, you give them the warning. I like to see the at will language in every one, not to this extent, not to this length. This is more, again, what you would find in a handbook, but just reminding the employee, nothing contained herein shall change the fact that you're an at will employee. We even put it in stock options for those of you who have those types of agreements, performance appraisal plans, any kind of comp plan to remind them that there's no guarantee. We have also express and implied agreements to terminate only for cause. Especially at the executive level, we very often write employment agreements where we define what cause is. If these certain things happen, that's cause, and we have the right to terminate you. If we terminate you without cause, a lot of times we've negotiated for an executive to come over and onboard, and so we have to pay them for taking the risk of doing that if they've left another position. So we might have language in the agreement that provides for a severance payment or some type of compensation if the employee is terminated without cause. Now, there are both written agreements and oral agreements for employment, and of course we highly recommend you use a written agreement. And the reason for that is if you have an express written agreement that says your employment is at will, the employee cannot bring a claim saying that I had an implied agreement that I would only be terminated for cause. And the reason for that is the law says you can't have an implied agreement that's contrary to a written express agreement. Now, if it's all oral, then you just have it two sides arguing. You often hear this, he said, she said. They're two different positions. That's not desirable. So we want to encourage everyone, if you're not already, to use employment agreements. Now, I know some of you like to use offer letters. That becomes your employment agreement. That's okay too. Some offer letters say sign the closed employment agreement. That's all right. We want something in writing that expresses exactly what the intent of the parties is. Okay, so at will sounds wonderful. I can terminate you at any time for any reason. I don't even need a reason. But then the California courts and statutes have come along and given us a whole slew of exceptions to that. You can't terminate anybody for illegal reasons, and that includes unlawful discrimination, unlawful retaliation, terminations against violation of public policy. Each one of these increases the risk, and we're going to go through a couple of the more common ones. The next slide is a list of the protected characteristics, or what we call protected classes. Anytime you have an employee in one of these protected classes, there's a heightened risk, and we have to do an assessment. Does that risk change the determination to terminate? So, for example, some of you who may have been on the webinar last year, I gave the story of a client who had been really frozen and terminated an employee. Lots of complaints about this employee's interaction with customers, to Linda's great standard of conduct, which I love, and plenty of facts to support termination. But because this employee was in so many protected classes, she was a female, she was over 40, she was a lesbian, and she was Muslim. They were afraid. They were just afraid. And finally, one of their top customers came in and complained about her and said, I'm not going to do work with her anymore. But they finally realized, you know, we can't continue to keep this employee just because we're afraid of these protected classes. The day they were going to terminate her, they had all the paperwork put together. They had her checks cut. She was driving to work and she got hit by a car. And so now she's got another protected class, disability, because she went out on disability that very day. So it made it worse. The thing about protected classes is we need to look at the facts behind each protected class. The fact that somebody's over 40 doesn't mean they survive any termination decision. It means, do we have any basis to determine that this person is being terminated because they're over 40? Or is it because of these other things that hopefully, if you followed Linda's recommendations, we have all the facts to support it's a legitimate reason. It's not because of the protected class. And we need to ask questions to determine that. So, for example, on over 40 claims, I asked the clients, has anybody made any complaints about this person moving too slow, saying they're too old? There's a case going on in Google right now about this very thing where a couple of engineers didn't like the older engineer that came in, and so they called him an old man, and you're too slow, you can't produce fast enough, you're never going to make it here. Those are the kinds of facts that would support a claim for someone over 40. If we don't have those facts, we don't take that into consideration. So with each one, we have to look and say, was this person teased or bullied about their sexual orientation? Did anybody say anything, or did it make comments to others? Do we have postings on social media? We got to go back and look at all the facts and see if there's anything to support it. If not, and we don't even put that into consideration any further in the termination process. Retaliation of public policy. This is when you have an employee who refuses to commit unlawful acts, and you'd be surprised how often this happens. You might have an employer who asks an employee to falsify records to produce to the government, to commit perjury on behalf of the employer, to violate antitrust laws, any illegal activity. The case laws, when these laws first started coming out, had to do a lot of times with dumping hazardous waste. But any illegal activity, if your employer asks you to do anything that's illegal, and you refuse and you're terminated, you have that potential claim of retaliation and a violation of public policy. The same as performance of lawful acts. So if you are trying to perform an act that you're allowed to do and your employer terminates you because you've done that, so for example, serving on a jury or refusing to take a polygraph, or more commonly, filing a workers' comp claim, if you're terminated for taking those lawful acts and exercising your legal rights, that's also in violation of public policy. And then, of course, whistleblowing activities. We hear a lot about that in the news, reporting unlawful conduct. So what are the most risky scenarios? Obviously, multiple protected characteristics, protected classes, and the reason for that is we've got to dive in and see if there's any facts, and sometimes, unfortunately, there are. And if there are facts to support those claims, we need to take some action to reduce that risk. And that means we might be looking at something other than termination. We might be looking at termination with a severance package and a release. But it's a heightened risk that we need to look at. The most common claim of protected class discrimination we are seeing now is disability. If you would have asked me this question 15 years ago, I'd say sexual harassment. We see those lawsuits all the time. What we're seeing now is an influx of disability lawsuits, and the reason is that the plaintiffs bar, the attorneys that represent the employees, really like this area because in order to be disabled, it's a very low threshold. The definition of disability is very broad. In some events, you could have the flu and possibly be disabled. So it's a very broad definition that's not hard to meet. It's not hard to get a doctor to certify that somebody's disabled. And now the burden shifts to the employer to show that the employer engaged in the interactive process and did everything it could to try to reasonably accommodate the employee. Well, the definition of reasonableness is open to interpretation by everyone. And certainly what's reasonable for Coca-Cola is not reasonable for Linda's Ethos human marketing. And so everything in between is what we discussed, and it could be anything. You could have a judge or a jury going either way. Because of that unknown, it makes employer side attorneys very willing to settle these cases, and the plaintiff's bar knows that. So they file a lot of these cases, and that's what we're seeing so many of. So very risky. If you have an employee who is out on disability and has been a performance problem, I strongly recommend you consult with counsel before making any decision to terminate. So lowering the risk, one of the other things besides the great recommendations Linda gave you is to run through a pre-termination checklist. And again, we're never going to take all the risk away, but let's do what we can to lower it. So we asked, did the employee have adequate notice of the company's standards? Linda went through where you find those standards. You're going to maybe onboard them with some training. You're going to have it in your handbook. You're going to have it in posters. If not, to Linda's point also, the supervisor didn't do their job. Okay, somebody didn't do their job. Employees should have all of your expectations as employers laid out to them. They should know exactly what they're supposed to be doing. Were the company's disciplinary procedures followed? Again, same comments with Linda. Check the handbook, check the policies. Was a thorough investigation completed? Was one legally required? You know, if you have claims of sexual harassment or discrimination, legally you are supposed to conduct, under the EEOC guidelines, an investigation. Was that done? Is the documentation sufficient? Were any representations or promises made regarding continuing employment? Again, if we have that at-will language expressly set forth everywhere, then we won't be tied to those oral promises. How long has the employee worked for the company? Did the employee give up other job opportunities or move to accept the position? Does the decision to terminate follow close to conduct that may be deemed protected activity? These are just a couple here, but also other ones we talked about earlier. Any whistleblowing, any protected activity, organizing for unions, discussions about wage and hour. Is the employee in the protected class? Very low on this list, right? It should not be the first thing on the list, but it definitely has to be on the list, and then we have to do that factual delving into the facts to see if there's any facts that support that it might be because of the protected class. And then if the employee is disabled or religious beliefs may have been a factor in the discharge, were all reasonable attempts to accommodate carried out. I would label that a bad bullet on this slide, and really that should be you could stick in any protected class where it says disabled or religious beliefs. We got to know if we accommodated the employee. Other considerations: constructive discharge. Constructive discharge is when an employee quits because the working conditions have become, quote, this is a legal term, intolerable, end quote. That's what the courts look at. It's so intolerable that a reasonable person would not be expected to stay. And it's important because if it was so horrible, if the working conditions were intolerable and the employee quit, it's deemed a constructive discharge, meaning even though they quit, they have the same rights as if they were terminated involuntarily. So they have the right to receive unemployment insurance benefits, and they have the right to bring these potential wrongful termination claims that we've been discussing. There's always a possibility of eliminating the position altogether, but what I would say to you here is don't lie, don't lie, don't lie. I have lots of employers who call and say, I'm just going to tell them I'm eliminating the position, but they're not. And don't do that. You don't need to do that. If you've properly done what you are supposed to have done with respect to their disciplining and documenting, then you don't need to do that. Because what would happen if you get on the stand later and you are going to put out all this great documents that Linda's taught you to do, we're going to use that in trial, and we're going to show the judge and the jury, look, the real reason we terminated this person was because they were a terrible performer. They never hit their sales target once. But then the employee's going to get on the stand and say, they told me they eliminated the position. And if you do the termination correctly, you'll have a witness. Yeah, that's what we said, but that's not really why. We just didn't want to hurt his or her feelings. I hear this all the time. It's horrible, because then the attorney on the other side is going to say, well, were you lying then when you terminated him, or are you lying now with all this evidence you're bringing in? So don't lie. There's no reason to lie if you've done your job properly on the other side. If you can truly eliminate the position, and by that I mean you're not putting anybody else in that position for at least 6 months, then that's okay. You can do it. That's one way to get rid of them. But I wouldn't use that alone as the reason, unless it's truly the reason, and often it is. We go through reorganizations and we eliminate positions all the time, and especially when we have downturns like in 2008, 9, and 10. We have to move people around. So please be careful with that. I get that all the time. I also get asked all the time, I'm just going to tell them I'm terminating them at will. Because you don't have to give a person a reason while you're terminating employment. I don't like that. Again, the reason I don't like it is if the employee is inclined to go speak with attorneys, I want them to know the reason they're terminated. Now, that doesn't mean I'm going to go through a litany of all their performance issues. But if it's poor performance and it's tied to some KPIs or measurable increments, then I'm going to tell them that's what it is. Because I want, when they take their personnel file to the attorney to see if they're going to take their case, I want them to know all the real reasons. And hopefully they might be able to pick somebody up. So I don't like terminating just at will. You can do it. Would the employee resign if you agreed not to protest a claim for unemployment insurance? I have a problem here as well as an attorney because we are not allowed to tell you to break the law. And the law is very clear as an employer. When the EDD writes you and says, what's the real reason for termination, you are under a legal obligation to give them the real reason for termination. Now, you can couch this with the employer. This is what we're going to tell them, and because this is the real reason, but we won't do anything else. We're not going to take it further beyond that. Separation agreements, also known as severance agreements. This is the best protector you can have if you need it. Now, if we have a very low-risk termination where we've properly done everything Linda's asked us to do, and we've got all of our documentation in order, then we have a very low-risk termination, we might not need this. But if we have someone who's in a protected class, and yes, we've had some racial remarks made, let's say, that's not the reason for the termination. We all in the room know it, but there's a lot of risk that that person's going to bring a claim, then maybe we engage in discussions for a severance agreement where we pay some money and get a release of all claims, with the exception of workers' comp claims. You cannot release workers' comp claims without going through the Workers' Comp Appeals Board, and it's timely, expensive, and I don't even know how inclined they are to do it. So what we do in our releases is we have them represent that they have not had a workers' comp injury, that they are injury-free from injuries in the workplace. This is a great way to sleep at night if you have a potential claimant and there are some facts to support some legitimate claims. Sorry. Okay, on the day of termination, provide the employee a final paycheck, including all money due, including vacation, commissions, do, if you haven't already, remember the laws changed regarding commission agreements, so the agreements need to be in writing. The most important thing is to determine when commissions are earned, because that's when they have to be paid. Now, it is possible that you have commissions that have earned, but they haven't been able to be calculated yet. If that's the case, it's all right. You can calculate it later and pay later and not be in violation of those requirements. The DE 2320 pamphlet from the EDD, there's a picture of it here. The notice to employees as to change in relationship. This is a little bit different than the notice I mentioned under the Labor Code section defining at will, which can be oral or verbal, or excuse me, oral or written. This one has to be written, and it's required under, I believe it's under the Unemployment Insurance Code. COBRA notice, if it's Cal COBRA, that obligation falls on the carrier. If it's federal COBRA, it falls on the employer. If you have a third-party administrator, you want to follow up with them and make sure that they get that done. And that concludes my portion.
Well, thank you very much, Marla and Linda, for helping us better understand the employee discipline discharge. I always learn so much more when I listen to you guys, and I'm always astounded at how much more I learn. So thank you very much. That does conclude the presentation portion of our webinar. So now we'd like to spend the remaining 15 minutes or so answering your questions. Now, some of you have already been taking advantage of that wonderful Q&A component as part of the interface for the webinar. Just type your question in there and send it to me. Some of you have also emailed me. You may email me directly at julie@thedoorgroup.com, and we will start right now by asking Marla and Linda a question. And I think, Linda, this one's probably for you. You were talking about doing an investigation during your presentation, and Janet was wondering if you would always recommend a third-party investigation when considering termination. You know, so you have kind of not only a little bit of an audit of, you know, the documentation that's in place, but then also an investigation that would support the decision to terminate.
Okay, thanks, Julia, and great question. You know, whether it's an outside investigation, you know, that takes place or an internal one, I don't know that it makes that much of a difference. Not every termination is going to warrant an investigation, but you certainly should make sure that you have all of your facts known. So it depends on the situation, I guess, is my answer. If it's a situation where this person's, you know, been missing a lot of time from work and you've written them up and now, you know, they miss more days and whatever, you're just going to fire the person, no investigation needed. If it's a situation, you know, I can think one where we actually fired a payroll person a number of years ago. She was essentially stealing money, embezzling, you know, then yeah, we actually conduct an investigation. Whether, you know, you need to have somebody from the outside come in and do it, that's fine. I think the most important thing, though, is that the person doing the investigation is trained on how to do investigations, right? So just don't have anybody do it. You know, hopefully if there's an HR person internally you can do it, the person's objective. Don't have the person's boss do it. Don't have the person's boyfriend, girlfriend do it. You know, all of those factors seem so obvious, and yet I'm sure Marla would tell you also, you would be shocked at what some companies do. So you want to make sure that the person doing the investigation, whether it's inside or outside, has been trained, knows how to conduct the investigation, knows how to document everything appropriately. So you do have all of those facts before you make the final decision on whether or not to fire the person.
Okay, great. Marla, did you want to add anything to that?
Well, I would just want to add, I absolutely agree with everything that Linda said. I think using outside investigators for every termination would be cost prohibitive. You just couldn't do it. There are some times when you should. You have to go outside because you can't find anybody inside who's not tainted. She said, you know, somebody's boss. You know, anybody who has a vested interest in that person staying should not be doing the investigation or have any relationship with them. But I also want to caution everyone not to become frozen. Okay, I'm using that term a lot for those of you who have kids. Just saw the movie. So don't become so frozen that you're not making business decisions, because that's what it is. It's a business decision. It is a legal decision also, but it's a business decision. It's best for the company for this person to be gone. And sometimes even the legal decision is difficult. I had a client who had a payroll service that provided free HR advice, and they had an employee that they wanted to terminate because he had physically hit somebody and had physically threatened somebody else. But because he was in a couple protected classes and he had not been written up on anything else, the HR service had advised against termination, and they called me and said, well, we just want a second opinion. I said, well, the second opinion is going to be completely different than the first, because you have an obligation to every single employee to have a safe work environment. That's a greater risk first of all, physical harm to anybody is a greater risk, in my opinion, to a lawsuit. That's a greater risk than a potential lawsuit over this protected class. So I would recommend that you terminate this person immediately. No investigation, no documentation, no prior written warning. You get that unsafe person out of there now. So you have to look at each situation separately.
I just want to say something, Jill, on that one. I think that's so true, and I think that's where I spend a lot of time coaching my clients is they're so afraid of getting sued. They just don't know how to handle the situation, and that's great. I mean, that's why I'm there, right, to help them with that. I think the other thing to what Marla's saying is, you know, as she said, don't be frozen. But again, you've got to look at sort of what's the flip side of this. If we don't take this action, what are the possible risks? And I think a lot of times that's not being looked at. So people get hung up on, okay, could I get sued if I fire this person? Of course. But you could do everything right and still get sued. You're never going to be without that risk, especially in California. So you have to take a look at what are the consequences. Again, it could be simple things like if we don't take care of this person, we stand the chance of losing some of our star performers who don't want to work with this person. Or it could be so serious as, you know, the example Marla was doing is, you know, we're going to have customers that aren't going to give us business anymore if they have to continue this, or we run the risk of additional claims from other employees if we have an unsafe, you know, or violent employee continue to come into the workplace. So always ask yourself that flip question as well, is what are the risks if we don't take this action?
Good. Okay, thank you. And Linda, you hit an angel's home run with your standard of conduct. Many of the listeners today really like that concept.
I love that standard of conduct.
As do I. The legal community agrees.
Oh my gosh, I love it.
A couple of questions. It's not in someone's handbook. Do they just do an addendum to it or wait until they get the handbook updated?
Yeah, I mean, you could certainly, I don't know what, you know, your internal policies for doing this, to go out now and just add one standard of conduct to the list probably doesn't seem worth it to me. Right. But, you know, people are going to be updating their handbooks next year almost universally because of the change in the sick pay law. And Marla and I have a webinar in January scheduled that we're going to be spending some time talking about that. So I'm sure everybody knows the governor signed a law that's going to require some changes to sick pay starting July of next year. So that's going to be a great time for people to update their handbook, review that policy if nothing else. But there's always little things that happen, and I always recommend to clients each year take a look at your handbook and see. So it's a great time to throw it in the standards of conduct. The other way you could do it is if you could just, you know, if you just want to reiterate the standards of conduct as a policy, you could just do that, and you could tack this one on at that point too and just say, hey, we just, you know, it's a good time for us to, you know, just remind all the employees these are the standards of conduct we have at company ABC, and, you know, post it, email it, have everybody sign off on it if you want to, but get it out there.
Okay, and Terry just had a quick follow-up question to that too. The beauty of this is that it's so general, right? She said she's trying to fight and resist the need to adding specifics underneath it. But you both would agree that it's better to keep it general because then it's kind of an umbrella that you can use in many different circumstances.
Exactly. That's exactly why I have it like that. Because like I said, it comes into play. Like, I'll give you an example. I was doing an investigation, a client about a month ago or so, where it was just two employees that the one employee just knew how to push the other person's buttons, right? It didn't fall into protected categories. There was no violation of a policy. He was just obnoxious about it, right? And so he would get on a roll and just start pressing buttons about how, you know, one type of phone was better than the other, one type of car was better than the other, or whatever. Now, we're not going to take that action with this guy to actually fire him, but we are definitely coaching him that he needs to basically play nice with other people in the department. It's a small department, you know, they have like low cubicles, open environment, and this guy would stand up and just sort of start preaching about his personal views on stuff, but specifically against this one other employee. And it's those type of situations where it wasn't a specific violation of other standards of conduct. It wasn't that he wasn't performing his job. Just everybody felt he was obnoxious. And that's the type of thing that I would use that for.
Okay, perfect. Marla, this next question might be for you because it kind of goes with the eliminating the position. And Tamara had a question. She said specifically, they have a need to eliminate a position because the responsibilities have changed due to retooling in a factory floor. And so it's basically becoming a position that has less responsibility, less authority, and they're reclassifying it. And she wants to know if we have to offer the new reclassified position to the existing employee, or you terminate and then allow them to reapply.
You can do it either way, but I'm so glad whoever Tamara asked this question, because I neglected to talk about terminations where you really are eliminating a position in a department where you might have 3 or 4 people in the department, and somebody's got to go, but not everybody. But we got one person who has to go. To properly go through the analysis for that termination, you should be doing a review of everyone. I always say make a little Excel spreadsheet or a diagram where you put everyone's name on the left, and then across the top put as many objective factors as you can. You can use seniority as obviously one of them. But even as a team player, if you can define what team player means, always ask the other members for work when they run out of work, that type of thing, so that you can show the reason you picked that one person was not because of any other protected classes, but because of this analysis you did. So you should do that. But for Tamara's question, you can do it either way. You can terminate them and say you have the right to reapply, but we're going to ask for others, depending on what the skill sets are. If they have all the same skills, you can just say, we're demoting you to this new position because this other position's gone. The employee has the right to turn around and walk away and say, I'm going to leave because I'm at will. That would not be constructive discharge unless it's a substantial reduction in the pay and hours are different. And we have had constructive discharge cases arise where the employee was required to drive 10 miles a day to work, and now it's 40 miles. That can be constructive discharge, so you have to look at that. But you can do it either way, whichever works.
Okay, good. Linda, did you want to add anything?
No, I think everything Marla said was great. I guess I do want to add something. I would say I think Marla's advice to say, make a spreadsheet and take a look at all those characteristics is really key, right? You can offer them the opportunity to work in another department if you have it. Depends on, again, the size of the company. If you're Coca-Cola, you've got a whole bunch of jobs to choose from, and if you know we're going to have to eliminate this position or this department in 6 months, a lot of times I've seen where they notify the employees ahead of time, again, not without risk, notify the employees ahead of time and say, look, this position is going to go away in whatever period of time, but in the meantime, take a look at the openings we do have, and if you're qualified, apply. They still have to go through the same whatever your internal process is for that, internal job bid process, and get selected by the hiring manager. They're not necessarily guaranteed that right, but they can apply, and if they get accepted, great, and if not, then their position gets eliminated and they go away. Just be consistent with whatever your written policy is. So if you say that that when we lay somebody off, we always, move them into other positions, or we'll give them the option of taking the cut and pay and staying, then make sure you do that.
Okay.
Yeah, and to that point too, also, if you say seniority trumps everything, then seniority trumps everything.
Right,
Okay,
exactly.
Good reminder. Thank you. Kind of along the same line, Maria has a question. Can an employee be placed on work share program due to the lack of orders after they return from disability?
Yes. However, whenever you have somebody who's coming back from disability, it's the same as going out on disability. There's the risk that they're going to say, this isn't the real reason this was done. The real reason it was done is because of the disability. So you want to make sure that you do have all that documentation. That, prior to your leaving, we had 1,500 orders. Now we're getting 500 orders a week or something. So this position needs to change. And again, if there's somebody else in that same department doing the exact same job and you're targeting this person, that's going to be a problem.
Okay.
That's why you need to do that analysis we just spoke about.
Okay, good. Lenny has a good question. In the example of the employee that was finally terminated after 10 years of absenteeism, I think that was Sally, does the fact that she was allowed to continue to repeat this behavior for such a long time in any way give her an argument that her behavior was acceptable because of the inaction by some of the previous managers?
Great question, and that's one of those flip side questions to ask, right? What are the consequences of not taking this action? And I think that certainly there's an argument to be made there, right, that it's tacit approval to do this. In this particular example, it wasn't that the manager fired her outright. We did go through, we'll call it progressive disciplinary steps with her, But the difference was where other people had written her up and said, here are the consequences, and then didn't enforce them, this manager was enforcing them. So she was saying, here are the consequences if you fail to continue to do this. And then when she failed to continue to do this, she suffered the consequences. So I think that's the difference in that. But I do think that Lenny's question or point is well taken, that is an argument the employee certainly can make, that, look, you know, I've been able to do this all this time. All of a sudden now I can't. You know, I think we can defeat that, but it's an argument they certainly can make.
Well, in your case, you had the additional fact that this was a new manager, and new managers are allowed to create their own team. If you're not on board with my team, then I have the right to let you go, and so that helps support that argument very much. Having a new manager, I always call it the changing of the guard. You know, the new guard comes in, and they want their people. That's a good time if you have employees who you've been thinking about terminating, you've been on the fence and you're not sure, that's a good time to do an analysis and clean shop.
Yeah, because I think the other thing that Lenny didn't ask in the question, but I think another point is true, is if, you know, I think another argument can be made, well, you guys are writing me up for this, but so-and-so in that department didn't get written up or fired for it, right? That comes up all the time.
Right.
You know, so you need to be prepared to say, okay, but the circumstances are different, or what happens in that department is, you know, has different standards than what this does. So as an example might be, you know, like, this isn't about a termination, but it's a good example. A number of years ago, we went on a 980 work week, an alternative work week, but I couldn't offer that to the receptionist because we needed coverage from 8 to 5. We couldn't say, oh, you can work 9 hours and then be gone half day on every other Friday. It didn't work from a business standpoint, so we're like, sorry, you're in a different situation based on your job responsibilities. So it's sort of the same thing. It's like this, the standards of conduct and the expectations may differ based on position.
Okay, great. Casey had a follow-up question. We've got just a minute here or so about that analyses that you guys would conduct where you're talking about, oh, you have 1,500 pieces, now it's down to 500. Do you have to disclose that analyses to the employees?
No, you don't have to. Again, you don't even have to tell the employer you're terminating them. You do not have to disclose it, but we want to have it because the purpose of it is a defense document that will be evidence against any claim the employee brings. So you definitely do not have to share that with the employee, and you most times wouldn't.
Okay, great.
Julie, let me add something that just reminded me of something I wanted to say earlier. So, Marla, I think you misspoke right there and said you didn't have to tell them you were terminating them. I think you meant to say the reason that you're terminating them. Right. You certainly want to tell them. So here's you guys want other language I use? Write this one down. I should have put it on a slide. So this, again, just happened last week with a client where you don't have to go through all the reasons you're firing somebody, and I recommend that you keep that conversation short and sweet. So the phrase that I train my managers to use is to say that either I or the company, whichever one, has made the decision to terminate your employment effective immediately. And then stop talking. If you've done everything else that we talked about and you've given them some sort of prior warnings or there was something so egregious that warranted termination the first time around, there's no surprise factor there. 9 times out of 10 they go, okay, and that's the end of the conversation. You go through the paperwork and you move on. The trouble happens when you all of a sudden, like what happened with one of my clients last week, give them like this 2-page document outlining all of their wrongdoing over the last however period of time, because all it does is invite a debate. And personally, I like to avoid those debates. And so again, I say, you know, all you got to do is say, I've made the decision to terminate your employment or to eliminate your position effective immediately. And then stop talking.
But let me add one thing to that.
Wait and see how they respond.
Yeah, let me add one thing to that I always advise my clients. Same thing. The decision has been made. The next sentence is always, it's not open for discussion, because Linda's absolutely right. Discussion is only going to harm the employer. It's not going to help at all. And I've seen employees talk their way back into positions and with more pay. So I always add, it's not open for discussion. And once they start, you have to be strong and say, I'm sorry, the decision has been made. It's not open for discussion. I tell my clients, if you've gone more than 5.5 minutes in your termination, you've probably gone too long.
Yeah, exactly. That's why I say it's a 5 to 10 minute meeting at most.
Good advice. Ladies, thank you very much. Linda, I'm going to ask you to close us out with just one little question here from Larry. He just wants to know if the webinar on anti-harassment training is satisfactory for the AB 1825. Is there a compliance component to that? Can you maybe share a little bit more with our audience?
Yep, it absolutely is compliant, Larry, with AB 1825. I'm going to issue afterwards, I'm going to issue some form of certificate so they can place it in their file. That's why it is 2 hours, and it will definitely be interactive. And we can actually, because we're going to use GoToWebinar, I've done this before, I have polls built in, I have discussions built in, so I can also track who is participating and who is not participating. So yes, so thanks for that question. Again, the registration is on here. If for some reason that's not working for you, let me know. It's set up through Constant Contact, and there's a PayPal button. You can just go there to pay. But if that doesn't work, just let me know and we'll work out some other terms. I also want to not only thank everybody for attendance today, to remind people we are dark next month, and we will be back January 14th. So mark your calendars right now. And it'll be new laws for the new year. So we will definitely spend some time on the new sick pay law, and then Marla's going to have some case law to go over as well. So until then, thanks so much for joining us, and we look forward to seeing you back in January, and happy holidays.
Thank you.
Thanks, everybody.